All right, I think that we are live on Facebook now. So welcome to Legal Lunch and Learn, which is a weekly live show where we ask an expert your questions on a legal topic. My name is Jenny Nance, and I'm a staff attorney here at Maryland Legal Aid in our Lawyer in the Schools program, which is part of the Community Lawyering Initiative. We partner with several Baltimore City public schools around the city to hold legal clinics and provide advice and assistance to city schools, families, and community members. And we often do this by connecting them with pro bono attorneys who volunteer their time to answer questions and help with paperwork. I'm very happy to have one of those volunteers with us today, and I'll introduce her in just a moment, but first, a few housekeeping notes. Our production engineer is Alec Chase. Alec, thanks so much for helping us out today. If you need to get a hold of us, if you need some legal assistance or have a question, you can email us at lawyer@mdlab.org, or you can call our intake line at 443-451-2805. You can also access us on YouTube for those who need captions. And finally, this doesn't create any attorney-client relationship. This is just general information. So our presentation today is on general litigation tips. It's a basic overview to help people, primarily people who are representing themselves, feel better prepared to go into court. And so I'm very happy that we have Kristina Miller to join us today to talk about this topic. She is an experienced litigator, and she is also a pro bono attorney volunteer with us. So she is going to be walking us through the process of getting a matter started, defending a matter. The other disclaimer I want to give at the outset is this is primarily civil litigation. So some of these tips will apply in a criminal circumstance, how you refer to the judge, what a courtroom looks like, but primarily we're going to be talking about civil litigation. So cases like a landlord-tenant or family law or debt collection, matters like this. So Kristina, thank you so much for joining us today.
Thanks, Jenny.
And if anyone has any questions throughout the presentation, please just drop them in the comments on this post and we'll hit them as they come up. So let's just jump in because we have a lot to go over. So just to start off at the very most basic level, in Maryland, we have at the state level, we have district courts, we have circuit courts. What's the difference between those courts?
Yeah, great question and really important question. So in Maryland, there's the court system, which is generally comprised of courts where you go in and speak with a judge, and then there's a whole series of appeals. We're talking about court. And when we're talking about going to court, there's two kinds, district court and circuit court. So district court is probably what a lot of the cases we're going to talk about today involve. That's small claims. So we're talking 5,000, 10,000. You cannot get more than 30,000 in district court. That's the point. Okay. So we're looking at things like trying to get back a security deposit. We're talking about if you have credit card debt and you're being sued over it. We're talking about minor car accidents, things like that. Those are district courts. And in district court, you go before a judge, one judge. Circuit court is different. Circuit court handles larger claims. So by that, I mean claims with more value. Because again, we're talking civil, so the money system. In circuit court, that's where family court is. So if you're doing a divorce or you have a custody dispute, you're in circuit court. And this is really important because the courts are located in different buildings. So a county will have one circuit court, but they can have many district courts. So for example, if you need to go to the district court for Baltimore County in Towson, well, you better go to Towson because there's plenty of other district courts. If you show up at the district court in Catonsville, it's no good. It's like you didn't come at all. So that's really the difference. District court, we're talking smaller levels of claims, a lot of landlord tenant issues, credit cards, debts, that kind of stuff. Family court, that's circuit.
Perfect, thank you. And what's some of the language that comes up when someone's starting a case that people should know as they're getting going?
Yes, so lawyers, you might hear legalese, the lingo we're talking about. Plaintiff, defendant, complaint. Those are the big three, right? So the plaintiff is, I'm bringing the lawsuit. So you have Mr. Smith versus Mr. Jones, right? Mr. Smith, he's the plaintiff. Then you have the defendant. That's the person defending defending against the lawsuit, the person who's been sued, who's saying, what are you talking about, Mr. Smith? I didn't do that. That's the defendant. And so the person suing is the plaintiff. The person defending is the defendant. And how do you sue someone? You file a written document with the court. And that written document is called the complaint. And that's important. It sets out what the case is about. So if you want to bring a claim against someone, if you want to sue someone, you have to put it in your complaint. If you're being sued, what you're being sued about is what's written in that complaint. So plaintiff, defendant, complaint. Also, an important thing to remember is that there is something called a fee waiver. You have to pay to file a lawsuit, and sometimes you have to pay to defend a lawsuit. I'll show some slides here in a moment, but there is a form you can download and submit in an attempt to get that fee waived. If you're a plaintiff in a case, if you're bringing a case and you ask the court, hey, court, may I have this fee waived by filing this form? And the court says, no, you don't qualify. Then you must pay a fee. Otherwise, your case is over. So let me just show some slides here, show you what I'm talking about. Okay, so in district court, what I'm showing you here is a complaint. This is what it looks like. Okay, and so you can see plaintiff, defendant, all that. This is a form you can get online. I understand those will be available to you through Facebook or some way to get it. All right.
Yeah, Alec, if you can drop that link in the chat in the Facebook comments. All of the courts have templates for different motions, complaints, everything. You can find those online, and you can also get them at the court. So there should be a link in the comments that will have all of these forms that are available from the courts. Beautiful.
So this is your form. Now, I will caution that if you're in circuit court, a lot of the complaints in circuit court are custom written by lawyers. So if you're in circuit court, you really need to talk to someone. If you're in district court, this is a form you can use. Now let me dig in here a little more. So at the top of that form, you have to start with where are you suing, right? And like I said earlier, there are several district courts. So you need to make sure you're suing in the right one and going to the right one. So that's the first step, the address, and you can pull it down here. And the next is how much money are you looking for? So you have to check your box, right? And then the last is what kind of case is it? Now, I don't pretend to know every kind of case that comes in court. Google is your friend. Most of the time, it's going to be a contract or a tort. So a contract is, we had this agreement, you breached it, you owe me money. A tort is a personal injury. So you invited me to your house. You didn't tell me that you own some giant poisonous mean snake that you allowed to, slither around everywhere, and it bit me. And now I have all these medical bills, right? That's a tort. So you complete that form that I showed on the last page. Those are what those boxes mean. And this CV number, that's a case number that the court will fill in. Whoops, hold on. Okay, then the rest of the form. So the parties and their addresses. So if you're bringing the suit, your name and your address. Now this is really important. Your address must be updated with the court and oftentimes with the MVA as well. If you move and you don't tell the court, that's too bad on you. So you need to make sure your address is updated with the court. Same with defendants. Put the address, their correct address, right? Here it says served by, which we'll get into a bit later. But what that basically means is if you're bringing a case, you have to make sure the person you are suing gets notice of it. You can't just pop it in the mail and assume they got it. You have to take other steps to make sure there's evidence that they are on notice of the case. So this is how, that's what that refers to over here. And now the particulars of the case, tell them what you want. Tell the court what happened, right? And then you can see all the other things you have to fill out in here, what it is you're looking for. So that's generally what we're talking about, plaintiff, defendant, complaint, how to bring a lawsuit, or if you get sued, what is it that you're looking at?
Great. So let's say I'm the plaintiff, and I filed my complaint with the district court or the circuit court. I filed it in the right county. I called the court to make sure I was filing with the right district court. What should I do now that I have filed my complaint?
Okay, your complaint is filed, and that's not the only thing you're going to need. You need something called a writ of summons. So let me explain it, and then we'll go into more detail in the slide. So you file your complaint, but that's not enough, right? If you're the one being sued, you think, well, what do I do with this? That's why you need a writ of summons. The writ of summons says, this is the trial date, this is where you go, this is what time you show up at. You have to serve, you have to give that complaint and the summons to a plaintiff. Otherwise, it's no good. Now, it's important to note that a summons will expire, but so you have, however many days it says on the summons to serve. You can ask the court to reissue it. So it doesn't mean your complaint's dead if you don't find the person in enough time. The court can reissue. So let's show the slides. Okay. Bear with me. Here is the writ of summons. This is what it looks like. Okay. And see, so it says the date it's filed, the case number, trial date, trial time, trial room. Okay. You have to serve this with your complaint. And somewhere on here, it'll say, however many days you have to serve it. And remember, you can contact the court to get it reissued, but you have to serve both of these. Now, sometimes, especially with COVID, things are a little bit different, right? There's different priorities these days, understandably. If you don't receive a writ of summons after you filed a complaint, call the court. There's a clerk's office at the court. Just, look up or find the district court that you need, call the clerk's office and ask. You shouldn't be afraid to do that. They can't give you legal advice or anything like that, but they can help direct you to where you need to go or help reissue that summons. Okay. Now, service, you've probably heard on TV, you've been served. Now, and that's really important because the defendant, the person being sued, has to actually have notice of the lawsuit. So service is formal delivery of legal papers to a defendant. You can do that. You cannot do it yourself, right? You cannot confront a defendant yourself and serve it. That's not appropriate. The ways you can do it are you can have someone else do it. It's called a private process server. So, I do that fairly often. There's people in town who do that. And they find the individual and hand them the papers directly. Or you can do something called certified mail. And that's why I have this here, this green card here. You have to do certified mail, restricted delivery, signature required, and return receipt. And so that's set out by law because that helps to ensure that the person who received this stuff was the right person, okay? And you need that return receipt so that you have proof that this person got notice. Now, I want to be clear that, how do I put this? Okay, everybody has a right to service, okay? It's essentially a right, okay? Like, so I can say, no, I'm not going to allow X person to accept it for me. You have to find me or you have to mail it to me through the certified process. That being said, a lot of times people become aware of a suit, right? They might receive something in the regular mail. Whether the process was followed or not, if you hear about or you catch wind that you're being sued and you need to appear in court, even if the process was wrong, it's really important that you still appear. And that's because you have to tell the judge that it's not right, okay? So the other side may say, I did this process. If you're not there, then how do they know that that process wasn't done? So what you need to do is still respond, still reach out and say, I was not served. I wasn't on notice. I need more time. Now, what that will likely result in is, right then and there, they'll serve you the papers. But the thing is, you can't run from it, okay? Because they will find you. There's people out there that will, and it's better to be upfront. That's the key takeaway here is respond and be on time. If there's anything you get from this talk, that's how you succeed in court, is show up, right? Respond, be on time. So let me see here. There's a little bit more with service. There's something called a military service affidavit. It's on that complaint form. What that's saying is, I'm certifying that the person who I'm suing is not in the military. So, you can trust that I've sent this to them through the certified mail process, et cetera, and they're not in the military, okay? And here's some links that can help guide you to how to comply with this. You can request information. Oftentimes it will come back to you as a printout or something in the mail saying this person is not in the military. And also just real quick, we'll get into this more in a second, but the writ of summons is really important because it also includes this notice of intention to defend. Okay, so we'll touch on that in a second, but that's how you would defend a case. So going back to it, the important part about service is if you're serving the case, you have to serve properly, otherwise it's no good. If you're defending against the case and you're not served, there's nothing really anyone can do about that, except the court might believe that you were properly served. And if you don't show up, then there's no one to say, Your Honor, that's incorrect.
The other two things that I was thinking as you're talking about is you can also have someone served by a sheriff, right? And then you could also, especially this comes up in family law cases, you could have someone served by another person, like a mutual acquaintance or someone that you both know, as long as the plaintiff is not the person serving them, right?
Totally. Absolutely.
All right, so let's flip the tables a little bit. Let's say I'm the defendant, and at this point in the process, I am actually the one who is served with the writ of summons and the complaint. So what do I do now?
Yeah, so you got to defend, right? As great as it would be to not worry about it, if you get served with a complaint, you have to deal with it. And so that's on the writ of summons at the bottom. Where was it? Let me go back up here. Here's your writ of summons. It says notice of intention to defend at the bottom. Okay. And so what you have to do is you have to send this back to the court. You only have 15 days to do that. It's tight. Deadlines are tight in court. What this is, a notice of intention to defend, is you're saying, court, Your Honor, judge, I'm defending this case. I'm not just going to allow a judgment to be entered against me. I don't agree that this is what happened. I don't agree that I owe this money. I want to defend the case. You have to file this. If you don't file it, you can lose your claim. So let's see here too. You'll also see this on that complaint form, application and affidavit in support of judgment. What this is sometimes a plaintiff can prove their case simply by giving documents to the court. They don't even have to show up. And so we see this often in debt collection cases. So for example, let's say you owe money to a credit card company and they want to collect on the debt. What they'll do is they'll file a complaint in court and then they'll file documentation of the money that's owed. If you don't file a notice of intention to defend, or if you do not show up in court when they say you will, the judge has enough information to say, yeah, you owe the debt, you owe a judgment. So that's the key takeaway here is to show up, right? And to face it head on. It's a really difficult thing to deal with a lawsuit. And so, things can happen if you're not there.
So the main thing is,
I'm sorry. I was going to say, I think that's really it. Like, this is really the key thing. If you file your notice of intention to defend, you put the court on notice. I want proof that that this claim is legitimate.
Okay, so the plaintiff has filed their complaint. They had the defendant served with the writ of summons, copy of complaint. The defendant answered, gave their notice to defend. So now we're actually approaching having to go to the actual court. So tell us a little bit about what to expect from going to court.
Yeah, the courtroom. It's a process. What I can say is find your biggest pair of patient pants and put them on, because it's going to be a long day. It's going to be a difficult day, and it's going to be frustrating because it takes a lot of patience to go to court and wait it out. So let's start with how do we get there, right? So there's all these different kinds of courts. You need to make sure you're at the right place. Oftentimes courts will start at 8:30 is probably the earliest, maybe 8. You need to be early because you need to make sure you're in the right spot. There's going to be security at every courthouse. There's going to be security, and there might you might have to lock some stuff in a locker, or, you know, hopefully you have a place to put it. So you need to be very careful of what you're taking into a courthouse. Oftentimes they will allow you to keep your phone. Previously, some courts would not, but you need to keep it on silent and you can't use it. This is very old school. So you need to be prepared for that. I would say bring a book, bring a magazine, be prepared to wait. When you get to the courthouse, the first thing you do is you go through security. You want to make sure I'm in the right place. So there's people around. There's sheriff's deputies. There's, you'll just see people walk around who look like they know what they're doing. Just ask them, say, you know, hey, I'm here. How do I find out where to go? Usually near the entrance, there will be an array of TV screens, and it lists something called a docket. So every case is identified in alphabetical order, and you find your case and make sure you're going to the right courtroom. Things happen, right? Maybe there's a plumbing leak in courtroom 1 and turns out now you're in courtroom 2. So every time I go to court, I always make sure I'm in the right building, I'm on time, and now I know what courtroom to go to. And then you go and you wait in your courtroom. You have to be prepared to wait. So this is where you have to be really patient, because everybody is told to get to court at the same time. So if court starts at 9, you'll have many people. I mean, you can have dozens of people who need to be there, who have trials all starting at 9. You have to be early, because if you're called first, you need to be ready. Because if you're not there, that's a problem. But you have to be patient, because you might be the last case. So you might show up at 8 o'clock and not get heard till noon, or you might have to come back in the afternoon, and you might wait all day. And the judge says, you know what? Unfortunately, I have to postpone everything, but you still have to be there. So it's really important to have that mindset going in, that this is, you know, just be mentally prepared. This isn't just going to be a quick trip, you know, to pick something up. You have to wait. Even if you have an appointment, everybody's appointments at the same time, and you don't know the order that you're going to get called in. So let's see here. Oh yeah. Don't complain about the wait. That's the other thing. You might have to wait a long time. When you finally get called up to talk to the judge, don't complain about it. They know, they do this all the time. He or she will not be pleased to hear you complaining about it. Let me show you what the courtroom looks like. So this is a typical circuit courtroom. And I know it's circuit court because here's a jury box. Okay. And so this would be, you have 2 trial tables. This is where, you know, one side sits, plaintiff sits on one side, defendant on the other. You have the judge. Now up on, this is called the bench. Up on the bench, there will be someone who works with the court or the judge. They'll often sit to one side or the other. And then on the other side, or somewhere in the courtroom, is a witness stand. There's also seats in the back. So when you're waiting back here in these seats in the gallery. This is also public. So anyone from the public can come in and watch, and that's where you would wait. District court is different because there's only a judge. It's called a bench trial, right? Because it's just the bench, just the one judge. This is what a lot of courtrooms in Maryland look like in some respect or another. So over here you have where the court clerk is often called, someone who calls the cases, who organizes paperwork, who helps the judge manage everything. And then on the other side is the witness stand. And so that's where if someone was calling to say, hey, I saw this car accident, they would go up to the witness stand. Now here's a tip. Approaching the bench, you have to ask for permission. So you have to be very conscious of the judge and the courtroom etiquette. And what that means is when a judge comes into a room, you stand. When the judge sits and says everyone can be seated, then you sit. When your case is called, you'll go up. You can't see it in this picture, but just like in the last one, there will be a place for you to go. So when you're called up, you go there. The judge will say, you know, good morning. Who do I have in front of me? And then you'll say, you know, good morning, Your Honor. My name is Joe Smith. I'm the plaintiff, right? Your Honor. You don't need to know the judge's name. You just need to know Your Honor. And you always call the judge Your Honor with everything. Your Honor, may I be seated? Your Honor, let's say you want to show the judge something. You say, Your Honor, may I approach? And then you go to the court clerk who will tell you whether or not the court clerk will take it, or you go to the judge. So it's a very artificial process. You have to be very careful and you need to be extremely polite. I ask the judge everything. And if you're talking and the judge suddenly interrupts you, That's okay. They can do it, but you can never interrupt a judge. That's just like complaining about the wait. Just forget about your case. So let me see here. What other notes do I have? Hang on. Okay. That's pretty much it for in person. You just want to make sure you know that the court cases, there's no like loudspeaker, they'll be called from the bench. So if you step out to go to the bathroom or something, time it as best you can, because if your case is called, you won't know the order they're being called. And if your case is called and you're not there, it's just like not showing up. What you can do is when you you get to a courtroom, before the judge comes out, the court clerk will say who's here and take a roll. That way, if you do go to the bathroom, someone knows that you were here and they can just wait a few minutes. But be aware and make sure you say your honor and be polite. Now, remote hearings, this is a whole other thing. This started during COVID. I think it actually might stick around. What this is instead of going into court and waiting in those galleries and waiting to, present your case in person, you show up to either a telephone conference or telephone hearing or a Zoom. This is court. You are still in court. So you will get a notice like this, and it'll tell you how to join by Zoom or whatever, Skype, whatever system the court's using, or how to call in. Now, you need to be early. And again, you need to be prepared to wait because this is tough, right? The court has all these people calling in. They have all these cases to deal with, and it's an evolving process. Everyone's still learning how to work with this. So if you get this remote hearing, make sure you test everything to make sure it works. If you have a question about it, call the clerk's office. Their number will be on the form, right? See, it says contact the court. They're expecting you to have, if you have questions, call. And what happens is there's different ways to do it, but it's a giant Zoom. And so you'll have, like, maybe you've seen on TV those like bands or viral sort of like flash mobs on Zoom, and you have all these little boxes of people. That's what it looks like. One of those boxes happens to be the judge, but all these other people are involved. Okay, you are in court the whole time. What does that mean? That means you have to dress well, right? When you're going to court, you have to dress professionally. When you're going to Zoom court, you still have to dress professionally. And so that doesn't mean go out and buy a suit. That means, wear a shirt that doesn't have graphics on it, right? You have to be in a quiet space. If you have children running around, if you have the TV on, everybody can hear it. Nobody likes it. You are in court. You have to have an appropriate background, right? You don't want, I can think of a lot of things I wouldn't want in my background that I'm not going to say. I'm sure you can think of plenty as well. You want an appropriate background, a white space, right? And just be early and make sure you understand how this works. Because, for example, things are evolving. There might be something like a waiting room. So you get in and you don't see anything, or you just get a notice on your computer that says, we'll be with you shortly. I've had that up on my computer for an hour and a half waiting for my turn. If you have a question, call the court and make sure they know, hey, I'm waiting. I just want to make sure everyone knows I'm here. But it's how it's going. I would say if there's any doubt, if you have a problem, call the clerk's office. Do not do this from your car. They actually issued an order telling attorneys, stop doing this from your car. You are in court, okay? Whether you're by phone or by Zoom, you're still there. And you need to make sure that you have everything just like you were in court. And also facial expressions. You're all of a sudden really close to the judge. So I have been called out for eye rolling. I don't recommend that experience to anyone.
Okay, great. That's super helpful. So the last topic we wanted to talk about was, up to this point, we talked about how to handle a case on your own if you don't have an attorney. Do you have tips that you would share for people who do have a lawyer that they're working with to represent them to make that experience work as good as it possibly can?
Yeah, if you're working with a lawyer, I think the most important thing is to be honest. You have to be open and honest with a lawyer. They can only shoot with the ammo you give them. And so if they don't know the whole story, then there's not really a whole lot that they can do. The thing about working with a lawyer too, there's a couple of things. One of them is deadlines are tight. And so you need to be responsive. I understand, I work with plenty of people who work multiple jobs and it's really difficult. But we have this court case and sometimes there's a deadline tomorrow and I need something from you tonight. Otherwise, when we go into court, I won't have anything that I can show the judge. So it's really important that you're responsive and that you're honest and that you communicate with your lawyer. The other thing is you need to make sure you understand what the lawyer is doing for you. If you don't understand what they're doing, ask them. It's their job to tell you, this is why I'm doing it. This is what I think we can do. Here are your options. So you need to make sure you understand what they're doing for you as well.
All right, perfect. So if anyone has any questions, feel free to shoot them our way. Do you have anything else, Kristina, that we didn't cover that you want to make sure that we hit?
Yeah, I would just say briefly, a couple of takeaways. Call the judge your honor. It's very important. Don't interrupt and don't complain about the wait. That's half the battle right there. The other half is probably showing up. Be on time. Deadlines are firm. I mean, I can't think of any other thing really where you have to respond. Otherwise it's over and you might never get to go back. So don't let fear and anxiety of the process prevent you from engaging in it, because it's not just going to go away. So show up. You can do it. Just call the judge your honor. Half the battle.
Perfect. Thank you so much. So if we don't have any questions, then I want to say thank you. Thanks so much for spending the time with us and for all the great tips. I think they were really useful. And if anyone has any questions later, feel free to leave a comment. We'll follow up, or also email us. And of course, reach out to Maryland Legal Aid if you know that you need legal assistance, or you know that you're going to need legal assistance. Like Kristina said, be proactive, reach out to us early so that we can make sure that we don't miss any deadlines and can give you advice to be able to do whatever it is you need to do for your situation. So that's Lunch and Learn for this week. Thanks so much for joining us, Kristina. It was really a pleasure to talk to you.
Thank you.
Thanks everyone for joining us.